prove. Even then also even then also I'm having respect over the marriage institution, and I want my wife or I want my husband back into my life, so to look after me and my children, so on, so like. So the burden shifts. So if the respondent proves that she or he has left the conjugal company by showing the reasonable grounds, then they will get. So the burden shifts on to the petitioner. So upon deciding the evidences, discussing on evidences and the law and appreciation of acts, the court will grant. So after granting of the restitution of conjugal rights decree, the person has to join the marital life. I mean, has to join the conjugal life within 1 year. So this thing, this limitation of 1 year has not discussed in this section, but it was discussed. We have to take a recourse from section 13 in divorce. I mean, section 13 grounds for divorce. Why? Because if a person fails to join the matrimonial life, that is conjugal life of the petitioner within 1 year from the court decree, so it will amount to the contempt, and it can be a ground for taking a divorce. So even if you want if you want the decree to be executed against them, then we have to take the recourse of civil law. I mean, code of civil procedure, execution of decrees relating to the matrimony. That will be discussed in order 21, rule 32 or 33, I think. Okay. So there it will be discussed. So now coming to section 10, judicial separation. Judicial separation. So here I would like to make a note with regard to this section 10 is, we have to, the people who are preparing for this judicial exams, they have to note this. Either party to the marriage, section 10 subsection 1, either party to the marriage, whether solemnized before or after the commencement of this act, may present a petition praying for a decree of judicial separation on any of the grounds specified in subsection 1 of section 13, and in case of a wife, also any of the grounds specified in subsection 2 thereof, as grounds on which the petition for divorce might have been presented. So here we can see section 10 of judicial separation, section 10, which is judicial separation, whether solemnized before or after the commencement of this act. So the marriage is solemnized even before the commencement of the act, that is on 18/5/1955. If the marriage is solemnized even prior to this date or after this date, this act is made commonly applicable retrospectively and also prospectively. So here here if you can see that so judicial separation on any of the grounds. So what are the grounds that are discussed? So on what grounds you can ask for the relief of judicial separation? That was the grounds that are similar to the grounds mentioned in the divorce, grounds for divorce. So the general grounds will be the having an extramarital affair, and next one is cruelty, desertion, renouncing the world, conversion, suffering with venereal diseases, leprosy, incurable form of leprosy. So these kind and some more are there that we will discuss in coming sections. So on these grounds, he or she can present a petition to the court for judicial separation. Separation in the sense means the court will grant the order of separate living, that is a spouse, for two spouses for an year. So if these persons will cohabit in this time after the decree of judicial separation, then the decree becomes null and void. So ultimately the person who says that the decree of the judicial separation has become null and void, is the burden lies upon him to prove the same, that the separation was not there, it was it was disturbed, and the separation was disturbed, and it has to be proved before the court who is contending the same, that is the judicial separation has been disturbed or something else. So judicial separation will be given on the grounds that were set forth in the section 13 of the Hindu Marriage Act. Now, coming to judicial separation, 10 subsection 2. Where a decree of judicial separation has been passed, it shall no longer be obligatory for the petitioner to cohabit with the respondent, but the court may, on the application by the petition of either party and on being satisfied of the truth of the statements made in the petition, rescind the decree if it considers it just and reasonable to do so. So, as we discussed, so when a decree of judicial separation has been passed, there will be no obligation on either of the spouse to cohabit, to live together, or to cohabit or live together. So if any of the party, if the both parties feels that the marriage is the disputes and something else that was that which are the grounds under section 13 have been settled, like if a husband files judicial separation against his wife, saying that cruelty, pleading cruelty. After passing judicial separation, they will the things were sorted out by them, and they started cohabit, living under one roof. But that means without the separation, they are living under one roof, and they can make an application then to rescind the decree of judicial separation. So by jointly or the petitioner who has got the decree, they can file a petition for judicial separation, the lifting of the, recall or rescinding the order of the judicial separation. So in this case, so if the both parties feels good to continue their marital relationship, then they can proceed for judicial separation. Feels the proceed for the further, they can rescind the order of judicial separation by making necessary application. If the order is complied strictly, that means there is no cohabitation between the both spouses for more than 1 year, then it becomes a ground for divorce. This was said in the section 13 that we will discuss.